Hello all, my name is Denise Stanitsky and my final topic I will be presenting to you is the case of RAV versus the City of St. Paul. The background of this case of 17-year-old Robert A. Victoria along with a group of teens were arrested for hate crimes in the City of St. Paul, located in the state of Minnesota, where RAV allegedly burned a cross on the lawn of an African American's family. This was illegal under the Minnesota's bias-motivated ordinance. This ordinance, which prohibits the display of a symbol that arouses anger, alarm, or resentment based on race, color, creed, religion, or gender. This is a landmark case because it challenged two historical cases. One, Chaplinsky versus New Hampshire, which ruled that fighting words fell outside the protections of the First Amendment. This case went into favor of New Hampshire because the words he used were intended to inflict injury and or disturb peace. And also secondly, Brandenburg versus Ohio, where the two-pronged test was put to use. The first part of the test was speech used directed to incite or imminent lawless action. Secondly, speech used was likely to incite or produce such action. This case was in favor of Brandenburg because the law in question was too broad and it cannot prove his teachings incited lawless action. The parties involved was RAV, that was the petitioner. The advocates that argued the cause for the petitioner was Edward J. Cleary. On the other side was the City of St. Paul, which was the respondents. The advocates that argued the cause for the respondents was Tom Foley. The argument of the petitioner from Edward J. Cleary was that the ordinance is viewpoint discriminatory and stating the use of the fighting words to the discretion of law enforcement makes this law too vague, and also that the law should be neutral regarding self-expression, not skewed to one side. And on the other side of the respondent, gave by Tom Foley, was four propositions to his argument. First was the purpose of the ordinance is to not limit freedom of expression, but to attempt to regulate possible harm that comes from bias-motivated conduct given by others. Secondly, the ordinance has been narrowly construed by the Minnesota Supreme Court only not to apply fighting words, but the ordinance presented reflects a particular harm going on within the city. Thirdly, the ordinance as construed is not overbroad or vague, but the ordinance is held up under the Chaplinsky and Brandenburg holdings of the U.S. Supreme Court. Fourth and final, the ordinance does not interfere with the First Amendment rights, but under the fighting words document, if it causes immediate breach of the peace, it is unprotected by the First Amendment. The relevant information of this case that this case went through two courts before being appealed to the United States Supreme Court. The first court was the trial court, which dismissed the charge. And secondly, the state Supreme Court, which reversed the decision of the trial courts. Finally, trickling down to the U.S. Supreme Court, which ended in a 9-0 vote under the majority opinion by Antonin Scalia, held the ordinance invalid, and it prohibits otherwise permitted speech solely on the basis of the subjects that speech addresses. This case went into favor of RAV.